Good
The
two
morning.
of you have conferred with Ms. Patrick from the front of the court. Ms. Patrick has recommended that spousal support be modified to be $350 per month commencing May 1st of 2024. Spousal support right now is $141 a month. Of course, your spousal support obligation is for 20 years. Mr. Ludi, that 20 years cannot be changed, but however, the amount is subject to modification per your judgment of divorce. Ms. Ludi is advising that she's had some increased responsibilities. Obviously, a disabled adult child, I don't think that's a proper expense. Ms. Ludi, and I'm sure Ms. Patrick will address that. In any event, Ms. Ludi, do you understand the recommendation?
The recommendation for?
$350 a month, beginning May 1st.
Yes.
Are you asking the court to adopt that recommendation?
Yes.
All right, Mr. Ludi, do you understand the recommendation?
Yes.
If adopted, it'll become an order of the court. And of course, if circumstances change, you can always file a petition to modify it or reduce it. Do you have any objection to the court adopting this recommendation this morning?
Well, I can't afford to pay it, so.
Ms. Patrick, obviously you went through the expenses, the increased expense of Ms. Ludi as well as the income of Mr. Ludi. Is that correct in coming to this recommendation?
That's correct, Your Honor. Mr. Ludi currently has got a warrant for his arrest. It's been out there for 2 years. He hasn't made a payment in 3 or 4 years. I know that does not have anything to do with the motion in front of us. However, the majority of the conversation was about the fact that he has a warrant for his arrest, and he spoke to the front of the court attorney several months back and was told to turn himself in. He's refusing to do that. So at this point, I believe that he can afford the $350 based on the information that Ms. Ludi has provided for me over the several years of him taking vacations and trips and things like that. So that is the basis of my recommendation.
Okay. Is there any merit in referring it to any type of formal investigation where they have to submit receipts, pay stubs, things of that nature, Ms. Patrick, or is that not necessary?
Your Honor, that would be great. However, I don't believe Mr. Ludi will do that. As I stated, for the last 2 to 3 years, he refuses to contact the front of the court in Monroe County. He will not tell us anything about his income. He just basically has been ignoring us for the last 3 years.
And Ms. Patrick would agree that the allegation, Ms. Ludi, that she now is care for a disabled adult child is irrelevant to this request?
We did discuss that, and I told her, she's an adult now. Mr. Ludi also brought up that fact, and I said that really doesn't have anything to do with what we're doing. So it's more so based on her expenses than on the adult daughter.
Did you also review the income of Ms. Ludi? Did she provide you with any information regarding her income?
She has done that in the past, Your Honor. She is on assistance, and so that's another reason why we had to be careful with how much we put on there, because we don't want it affecting her insurance and her assistance that she receives from DHHS.
Okay. All right, Mr. Ludi, obviously it's difficult when you've not been forthcoming about your finances. It's pretty hard to address this matter when you're not forthcoming about those financial matters. Do you want to hire an attorney, Mr. Ludi?
Well, Your Honor, I haven't been working. I was in a car accident in November of 2022. So I've been going through that ordeal.
Mr.
I can't work because my blood pressure is way above normal. So.
Okay, Mr. Ludi, 2 comments. First of all, if you can't work, you need to apply for Social Security. Have you applied for Social Security?
Yeah, that's what I'm trying to do.
What do you mean trying to do? Either you have applied or you've not.
No, I've been looking into it.
Well, think about it. Well, Mr. Ludi, you're sitting on your hands. Number one, when you're not working, you need to come and talk in front of the court. Explain your circumstances. I can't work. I've got these medical issues. Provide some medical reports. File a motion to reduce your spousal support. You've been sitting on your hands and taking no action whatsoever. So shame on you. And then secondly, you need to file for Social Security if you cannot work. You need to have medical documentation that you are incapable of employment. If in front of the court is a 4-page list of employers that are screwing for employees, you get a job at a clerk at a gas station. You can just sit it behind a window. It was not going to affect your blood pressure, Mr. Ludi. There's a lot of jobs out there. So at this point in time, the court's going to adopt this recommendation. Your support's going to increase to $350 a month beginning May 1st. It's going to force you, if you have a problem with this, you need to file a motion to reduce it. You got to be proactive, Mr. Ludi. Otherwise, you're going to get buried by this obligation. It's not going to go away. It's going to increase. You got a bench warrant. You need to come into the front of the, put some money together, come in and talk to the front of the court, ask the bench warrant to be canceled, and file a motion to modify spousal support to reduce it. But right now, you're not being proactive. And that works against you, Mr. Ludi. You need to be forthright in your finances and be proactive. So if you want this bench warrant, you're going to be stopped for speeding or something, and you're going to be sitting in jail for a period of time, Mr. Ludi. I'm just suggesting you be proactive. Stop sitting on your hands, come down and talk to the front of the court, and with that, you should obviously bring down a sum of money. Miss Patrick, how much are the arrearages, approximately?
Your Honor, the arrears on this account are $5,185.88. As I stated, we have not received a payment since September of 2021.
Okay. Mr. Ludi, if you've been paying all along, Ms. Ludi probably would not have filed this motion for an increase. But your spousal support is basically doubling now. It's doubling because of, and if you put yourself in this situation, you force her to file this motion. So of course, encouraging you, be proactive. We get some money together, you try to get $1,000 together, come down to the front of the court, talk with the front of the court, and the court will be inclined to cancel that bench warrant, get you back on track. You can pick up a form. You can file your own motion like Mr. Ludi did to reduce spousal support. And again, once you pay off these arrearages, that may cause Ms. Ludi to consider, reducing it back to where it is right now. But right now she's struggling because you're not paying the spousal support that you agreed to pay. You had an attorney at the divorce. As I recall, let me look at the judgment of divorce. You did not, but this is something you agreed to, the spousal support. Do you have any questions, Mr. Ludi?
No. Well, I mean, I didn't agree to the spousal support, but no, I don't have any questions.
Hold on, you didn't agree to it?
Motion.
There was a judgment of divorce entered. You did not object. You mediated with Ms. LaPrade back in August of 2020. An agreement was placed upon the record. You agreed at that part of settlement to agree for $141 a month for 20 years. The duration is not modifiable, but the amount is modifiable. You agreed. That was not ordered by this court. I simply adopted your agreement, Mr. Ludi. Come on. So I'm telling you what you need to do. You need to, if you want to straighten out this matter, you need to get the $1,000 cash together. You come down in front of the court, pay that toward your arrearages. The court, and again, you should do that in the next month or so. And then pick up a packet, ask that the bench warrant be set aside, and pick up a packet to modify support. But with that, if you're going to modify support, you need to provide documentation regarding your income. And I'm telling you right now, sitting at home, who's supporting you? Who's paying your bills right now if you're unemployed?
Say that again. I didn't.
Who's supporting you right now, Mr. Ludi?
Oh, I stay with my wife.
Oh, okay. Well, you ask your wife to get you help you with these obligations. If you're choosing not to work there, you can come down. There's a lot of jobs available, Mr. Ludi. You just got to be proactive. With that, the court will adopt the recommendation, and that will conclude this hearing.
Thank you, Your Honor.
We both mailed copies to her. Thank you, Ms. Patrick. For the record, this matter is before the court on the defendant's objection to a referee recommended order of child support. This hearing is being conducted via Zoom. President appears to be the defendant, objecting party Justin Hurst. Also, Mr. Kaczmarek, you've been retained by Ms. Eby. Is that correct? And you're appearing with Ms. Eby this morning?
That's correct.
Thank you, Mother. Very well. The parties have conferred with the front of the court this morning for the court to receive final recommendation that the referee recommend order be adopted but modified. Namely, during the school, it's supposed to be modified relative to paternity time. That during the school year, fathers shall have every weekend, Fridays at 3 p.m. until Sunday at 6 p.m. During the summer, fathers shall have Thursdays at 3:30 p.m. until Sunday at 6 p.m. The parties shall share holidays as agreed. If they cannot agree, then they fall back to be the front of the court holiday schedule. The fathers shall have such other parenting times the parties can agree. The parties will pay all extracurricular activities that are agreed upon, 50-50. In the event the school continues to recommend tutoring, the parents shall share that expense. I presume that they're shared 50-50. Is that correct, Mr. Kaczmarek?
That's my understanding, yes.
Okay. In addition to extracurriculars, the tutoring expenses will be shared equally. find a uniform support order dated June 26, 2024 should be adopted.
Judge, that amount was the 342, is that correct?
Yes, that's $342 commencing June 1st, 2024. Now that's a recommendation. Mr. Hurst, do you understand the recommendation?
Yes, sir.
Are you agreeable with the recommendation?
Yes, sir.
All right, so Mr. Kazmarek.
My client is agreeable, yes.
Wonderful. Do you wish to wire your clients, Mr. Kazmarek? Obviously, Ms. Eby did participate in the discussions this morning.
No, thank you.
Mr. Hurst, do you have any questions?
No, sir.
All right, the court will adopt the recommendation with an order of the courts. A copy will be mailed out to you. Please keep in the front of the court informed of any changes of the address in the future, so you receive copies of all the orders and so forth. Okay.
Yes, sir.
All right, thank you, Mr. Kazmarek. That will conclude this hearing. Everyone can zoom out. Have a good rest of the day.
Thank you.
Thank you, Your Honor.
Thanks for working through that. Obviously, when I looked at the objections, Mr. Hurst, it seemed more of a support objection. Miss Stephanie. Okay.
Sorry, I did that one.
Okay, thank you, Miss Stephanie. I appreciate you taking the time to work through that.
Not a problem.
For the record, this matter is before the court on the defendant Floyd Huggins' objection to a referee recommended order of child support. This hearing is being conducted via Zoom. Sir, are you Floyd Huggins?
Yes, Your Honor.
Well, Donna Hicks present.
Yes, I am.
Oh, good morning, Miss Hicks. You popped in. I didn't see you originally. The two VIP first, Ms. Brown, for the front of the court this morning. Ms. Brown has recommended that the referee record order be adopted. I believe, Mr. Huggins, your primary objection, you claim you couldn't afford the $140 a month. You understand the recommendation, Mr. Huggins?
Yeah, I understand it, Your Honor. I had a disability hearing on the 6th, and I'm waiting on the decision now.
Speak to any of your advice. I'm not catching all your responses, Mr. Huggins. Maybe speak a little bit louder.
I said I had a disability hearing on the 6th that I provided proof of, and I'm waiting on the decision now, Your Honor.
So, but you're still working 20 hours a week, right?
I'm not working no hours a week. I'm not working no hours a week.
Well, how do you support yourself?
I'm waiting on disability, Your Honor.
Well, again, but until that could be 6 months from now. How do you support yourself right now? Who's paying your bills? Who's feeding you?
I have my ex-fiance and my friend that helped me, Your Honor.
Okay, well, but that should motivate you. Unless if they want to keep supporting you, that's fine. But unless the court has some documentation that you are incapable of any type of employment, this is based upon 15 hours, 20 hours a week. I mean, the front of the court has a 4-page list of employers that are screening for employees, even if you have some limitations, Mr. Huggins. I'm not going to get into all the details, but you can get a job at clerk at a gas station, sit behind a window. There are positions out there that might be able to accommodate your alleged disability.
Yeah, and the hearing
not very much. So you need to explore those employment opportunities, or provide the front of the court with documentation that you are 100% disabled.
I can't do that until they send me the paperwork, Your Honor, from the judgment. I just seen them 2 weeks ago.
You saw who? The doctor?
I just had a hearing. I provided proof, and you should have the proof right there in front of you of the hearing I had on the 6th.
Okay, maybe the front of Ms. Brown, you have documentation. You had a Social Security disability hearing.
He did attach the letter that he had a hearing on June 6th with Social Security to his objection. It should be in the clerk's file. He states that the judge told him it was possibly approved. He couldn't tell me if it was SSI or SSD. Could not tell me a dollar amount of which he would receive or when he would start receiving any money. He did tell the referee in the hearing that he has provided transportation to other individuals and they have paid him money or paid utility bills for him. So it sounds like he has the ability to at least drive and make money.
I can't make people need rides, Your Honor.
I understand that, Mr. Huggins. You can't make people that take rides, but again, obviously there might be some local transportation services, you can drive vehicle part-time, even though you're no longer, you can't work for Bell Transport anymore. You can't do any physical work. There's still something you can do. So
My
the
lawyer
court's going-
told me to not do trying to do no type of work because I'm disabled, Your Honor. Y'all telling me to go against what my lawyer told me to do.
Okay.
I'm disabled, Your Honor. I can't work. Y'all trying to tell me to work. I can't do nothing but wait on the work to provide y'all the paperwork.
Well, you have what are we gonna do with this child? The child needs to be supported, Mr. Huggins. What do you suggest? Who's gonna support your child?
Hey, all I could do is tell you I got paperwork coming, Your Honor. Whatever decision you decide to make, that's on you, Your Honor. I can't do nothing but bring the paperwork back to you when I get it.
Well, when you get your Social Security, then you can catch up on these arrearages, Mr. Huggins, but this child needs to be supported.
What
Right now.
rearages?
Well, because of this child support order is going to take effect, and you're going to build up arrearages. If you're not going to pay anything, you can build up arrearages, which you need to then pay off when you get that Social Security.
So y'all so child support do take money out of set incomes?
Well, I'm not sure what state income you're talking about.
I said set incomes. I was advised by my lawyer that child support can't touch a set income.
Well, have your lawyer represent you in this matter, Mr. Huggins. Are you receiving unemployment right now?
No.
Why haven't you applied for unemployment?
Because I didn't have enough work history.
Okay. Have you not received unemployment in the past?
Yeah, when everybody received it.
Okay, well, I mean, reapply for unemployment until you get your Social Security. But someone's got to support this child, Mr. Huggins, so the court's going to adopt the recommendation that the order for $140 a month on your part is ordered. And you can address any arrears that builds up. You can address that this earth time you get your Social Security. So keep in touch with your lawyer and keep tabs on Social Security to get them to make a quick decision. Ms. Hicks, do you have any questions, concerns?
No, sir.
Okay. Maybe I don't know if there's something you can even do at a computer, Mr. Huggins. Explore the options with your attorney.
So when something got to be paid before y'all decide to lock me up for something I can't pay?
Well, keep contact with the front of the court. I would suggest you talk with your caseworker every other month and let them know that keep them informed of what's going on.
I mean, I've been trying to talk to them every time I go down there. I get a problem with them, Your Honor.
It's when you ignore things that bench warrants issues. So keep in contact with the front of the court caseworker, Mr. Huggins, and let them know what's going on. And that will certainly avoid the issuance of a bench warrant. All right, so good luck in that Social Security claim. Mr. Huggins, reach out to your attorney, but the court's going to order the $140 a month for your child support obligation. And the court will adopt the roughly recommended order. All right, that will conclude this hearing. You can both zoom out. Have a good rest of the day. Good luck, Mr. Huggins.
Is this appealable?
I'm sorry?
Is this appealable?
Sure. Talk to your lawyer. You go to the Michigan
I don't
Court
have
of
no
Appeals.
lawyer for this case, Your Honor. You keep saying lawyer. I don't have a lawyer for this case.
Okay. But I'm sure your lawyer can give you some general direction. Yes, you can appeal any order of any court to a higher court.
All right, thank you.
You're welcome. Okay, you can both zoom out.
Aaron said he hurt his back in a car accident. She goes to get
Driving the same car.
Well, I went on and I pulled him on my Facebook.
I did too.
I did, I was snooping over here. I was
I
like,
did too. I was like,
let's see. Let me see if he really, I don't see anything.
I wonder if he's on there.
I mean, he's on there.
Yeah. Let's see all his bling he's
But I
wearing.
mean, the last thing he's posted was 2020, November 2023.
Look at all his bling he's wearing.
Mhm. Those look like keys, don't they?
I loved it when they'd come in person and Judge would go.
Oh, I know.
How much can you give us?
Now, Andrew remembers that well
Oh, yeah.
because,
Used to do it downstairs.
Yeah. Point out to him and go, look at her nails, she's got her
Uh-huh.
nails done and she's carrying a, expensive handbag.
Yeah, iPhone and you can afford to get your nails done, you can't tell them you can't afford court fines, pay
Yeah.
child support, whatever.
Exactly.
Because I don't
Yeah.
do any of the above. And nor is I have an iPhone visit for you.
Okay.
Right?
No.
But yeah, all these people here. Chris is gonna take the 10:30. I'm gonna put them in for
for the record, this matter is before the court for the purpose of reviewing defendant father's parenting time, and this hearing is being conducted via Zoom. Present is Attorney Leah Worka, representing plaintiff mother Jessica Fent. Ms. Fent is present, and the defendant father Daniel Fent is also present. Good morning, everyone.
Good morning, Your Honor.
Good morning.
Parties have conferred this morning with Ms. Patrick from the front of the court, who has provided the court with fine recommendation. That father's parenting time will continue to be suspended, and he will petition the court once he's completed the court-ordered drug and alcohol assessment, as well as a comprehensive psychiatric evaluation. I believe that was ordered back in May of 2024.
That's correct, Your Honor.
The court can only assume that Mr. Fent has not made any progress toward that. That's the reason why the court set this review, is I hope that Mr. Fent would be moving forward in that direction so we could reestablish some limited parenting time. Mr. Fent, do you understand the recommendation?
I do, Your Honor.
Your response?
I have been having some major disconnects with getting in touch with the providers from prior to May, and the actual assessment and drug and alcohol evaluation and mental health assessment. I guess I just didn't quite understand exactly what was needed to be provided. And I mean, I'm sorry, I know that ignorance is not acceptable, but I genuinely just did not know. And I wasn't entirely sure as to what was needed to supply to her attorney. I thought it was just the fact that I completed the program and that there was an assessment done. I was not aware that the full assessment had to be presented to her in the court. That's what I understood from the beginning.
Well, have you secured an assessment, substance abuse and
right now I'm
assessment?
I'm currently in a intensive outpatient program that does also have a mental health and substance abuse programs. They're separate. I have talked to a nurse practitioner. I have talked to a therapist, and I am undergoing that treatment right now. I'm seeing the IOP program on Mondays, Tuesdays, and Thursdays. I guess from what I understand, that it needs to be a psychiatrist. So I am seeing the nurse practitioner tomorrow, and I'm going to see if I can see their psychiatrist there, who is a PhD. But once again, I just don't know exactly what I need to provide to the court.
Well, it seems like you're moving in the right direction, Mr. Fent. So, Mr. Work, have you received a copy of the assessment that Mr. Fent's referring to?
Your Honor, we've received no verification or documentation of any kind from Mr. Fent that he is engaged in or completed any form of mental health or substance abuse treatment or any evaluations. To the best of my knowledge, Your Honor, a nurse practitioner is not qualified to do a comprehensive psychiatric evaluation. Mr. Fent has alleged that he's been in an IOP program, which again, to the best of my knowledge, is not where one would have a comprehensive psychiatric evaluation completed. So I don't believe that those have been done. He also hasn't provided any verification of the IOP attendance. Mr. Fent has a history of making misrepresentations to this court. So absent any form of documentation, I don't have reason to believe that he's completed any sort of evaluation from anyone.
All right, thank you. So, Mr. Fent, once you complete this program, you need to provide some documentation, the document or a report that verifies what you've done, that you've been engaged in this intensive outpatient program for 8 weeks, 12 weeks, whatever, that you successfully completed all requirements, the prognosis is good. We need some positive written reports to verify all these things. And secondly, when you meet the nurse practitioner, you need to need a full psychiatric evaluation. Some of the issues that have been raised by Ms. Fent in the past to address those. So I guess we need two things. One, you're a alcohol and substance abuse assessment once you complete the intensive outpatient, as well as any documentation showing that you're also you're addressing mental health issues. We just want you to have a good relationship with your son Noah, and that Noah will be safe in your presence. So we can't move forward in terms of parenting time until you address those matters and get help for those issues to make sure that both you and the minor child are safe.
And so you're saying that I need to see a psychiatrist in order for that to be valid?
Yes, I believe that that'd be the appropriate person. So talk to the nurse practitioner about that. You've been sent orders in the past. In terms of, it says your parenting time should remain suspended pending proof of your alcohol and mental health treatment, in addition to a comprehensive psychiatric assessment.
I didn't have documentation. I mean, I was even asked that question yesterday by the person who runs the group if I needed any information, and I wasn't sure what to say to her in that instance. Is that something that I can provide to the court and Ms. Rorka? And is there anything we can do in that regard? I just didn't really know what to provide, to be honest with you.
Well, you take a copy of this order to your providers and tell them what you need. Again, when are you going to complete the intensive outpatient? Is that ongoing? Are you going to complete it in 6 weeks?
Yeah, it's 6 weeks. It should be done. What I was told, the week of July 8th is when I'll be finished with the IOP program. And yes, I will be definitely bringing that up to the nurse practitioner tomorrow when I see her. I'll have to look at the exact time, but I believe it's in the morning sometime. I've also brought it up to her previously. And I guess I wanted to wait and because I had the appointment on the 27th, I did want to ask the court because I thought, would that be enough? I didn't really know. Now I know it's not. So I will make sure to push that issue and get a comprehensive psych evaluation done as soon as possible. But I am moving in the direction that you're suggesting, Your Honor. I really do want to be a part of my son's life. And I do understand that this is very important, and Noah's safety is very important to me. I'm just a little bit ignorant to the way things work in this system. I'm also reaching out to an attorney to try and represent me in the future because I do not have an idea what I'm doing here. And frankly, her attorney is eating me alive here. I don't really have a lot of legs to stand on. I'm doing the best that I can.
No, you're doing the right things, Mr. Fent. First of all, you've appeared, which is important. It shows you're interested, and the court believes in good faith. You are trying to address these issues that you perhaps just simply don't fully understand what you need. So take copies ordered to your treatment providers and talk to the nurse practitioner about getting a full psychiatric evaluation and assessment. And since you're moving forward in good faith in the right direction, the court will set this for review. We'll set it for review sometime in perhaps in August, late August. You're going to complete your intensive outpatient in July. It may take a month to get that assessment. So Ms. Patrick, the court will adopt the recommendation, but we'll give Mr. Fent a review date so he does not need to petition the court, and hopefully he can provide that documentation to Ms. Rorka as well as the front of the court in the interim, Mr. Fent. So you need to provide that to Ms. Rorka as well as the front of the court before we come back. So let's look for we'll put this back in our docket. Do you have the dates that have gone? I'm thinking maybe August. In August, 13th, 14th, 20th, 21st.
I'm not available for that week in August or the following. Could we look at the week of August 26th?
Okay, August 27th or 28th.
Yep, I can do the 27th.
How about August 27th, Ms. Rorka?
That works for me if the court has a morning, if possible.
About 8:30.
That works, Your Honor.
Mr. Fent and Mr. Fent, will that work at 8:30 in the morning, or is that not a good time? Do you want it later in the morning?
I honestly, I'll probably end up having to take the day off, so I'll make it work.
Well, we don't want you to take out time off work. When do you get off work, Mr. Fent?
Oh, 2:30 in the afternoon. So I mean, if it has to be in the morning, preferably, I can
Doesn't
do that.
have to be. You get off work at 2:15?
It ranges, Your Honor. I'm in automotive, so it could be 2:30, it could be 4:30, depending on part of the launch. So
All right.
got to take a day.
I can't do the afternoon on the 27th. I could do the afternoon on the 28th.
All right, we'll do the afternoon of the 28th then. 3 o'clock or 3:30, Mr. Fent? What's better? We'll give you time. We'll set it for August 28th at 3:30.
I don't want to say that I can make it, and then all of a sudden my job, they could be like, you got to work till 4:30 today. You know, I would rather just take the day off and know that I'll be available for that day. And that's okay with me. I still get paid for it. You know, I'll make sure I have them known in it. They'll know well in advance, and I'll be able to make it.
All right. Well, if you're going to take time off, we'll leave it then August 27th at 8:30 then.
Okay, that's fine with me.
So, Ms. Beth, if you just put in the date, the court will review all these matters August 27th, 2024, 8:30 a.m. via Zoom.
Yes, Your Honor.
All right, so we'll include that review date in the order, Mr. Fent, and move forward. Hopefully, we'll have all it in front of us so we can reinstate some parenting time at that time. All right.
Thank you, Your Honor. I appreciate it.
Anything else, Ms. Vorka?
Not at this time, Your Honor. Thank you.
All right. All right. Thank you, Ms. Patrick. All right. That will conclude this here, and everyone can zoom out. We'll see everyone in August.
Thank you.
For the record, this matter is before the court via Zoom, or I believe for presenting some proofs on the record to stop the court's time performance guideline clock. Present this morning is Attorney Anthony Breskel, representing the plaintiff Andrew Pease. Mr. Pease bears to be present with Mr. Breskel. In addition, Attorney Maria Zagorski is present with the defendant Amber Pease. Good morning, everyone.
Good morning, Your Honor.
Good morning, Your Honor.
Thank you for being proactive, Mr. Breskel and Mrs. Zagorski. The court notes that the complaint was filed back in November. The parties were exploring reconciliation, so the matter has been adjourned a number of times. Currently, mediation is scheduled for July 8th, but that will be rescheduled. Is that correct?
Hopefully, we won't need to reschedule. We believe settlement is possible between the attorneys and our clients.
Okay. So we just want you to just place the proofs on the record this morning. Is that correct? And another pre-trial, or do you want to leave the July 8th on? Or are you unavailable on July 8th, Mr. Breskel?
I'm unavailable on July 8th. I just found out yesterday about a conflict.
Okay. So this morning we're just putting the proofs on the record. Is that correct?
Yes, Your Honor.
Pre-trial date and sometime mid-July without mediation?
Yes, Your Honor. With regard to the pretrial date, I think mid-July should work.
Okay. All right, then we'll look at some dates. In the meantime, we'll take the proofs. Mr. and Mrs. Pease, can you both please raise your right hand to be sworn, please?
Speak loudly, please. Yes, pay.
Ms. Pease, can you respond?
Yes.
Thank you. Please speak up so we capture responses to all the questions put to you this morning. All right, Mr. Breskel, begin with Mr. Pease, please.
Yes, Your Honor. Judge, I wanted to let you know that both Mr. and Mrs. Pease have a hearing impairment, so we're utilizing closed captioning this morning on our end. I will be speaking a little slower just so they can read what's going on the screen.
Thank you.
That's fine. Thank you. Andrew, is it true that you filed a complaint for divorce on November 9, 2023? That is the date that you signed a complaint in my office? Yes. Were all of the allegations in that complaint true on that day? Yes. Do they remain true today? Yeah. Were you married to your wife on July 23rd, 2013 in Monroe County, Michigan?
I believe it's June 23rd, 2013.
There may be a discrepancy in the date. Is that correct?
That's today behind.
We will correct that.
Okay, thank you.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage can be preserved?
I believe so.
Is that a yes?
Yes.
Were there 3 minor children born during the marriage?
Yes. Same wife.
To the best of your knowledge, is your wife currently pregnant?
No. Okay.
Okay, thank you.
You're
Judge, I
welcome.
have nothing further.
Okay.
Thank you, Mr. Breskel. Ms. Skorsky, do you have any questions for Mr. Pease?
No, I do have a couple for my client.
Please.
Amber, would you please tell the court the day that you and Mr. Pease were married?
June 21st, 2013.
June 21, 2013. And are you pregnant?
No,
You heard your husband respond to Mr. Breskel's questions, correct?
that's,
Were his answers true and accurate?
that's,
You've both been residents of the County of Monroe and the state of Michigan for several years now, right?
that's,
And you still are today?
that's.
Okay, thank you. That's all I have for my client, Judge.
Thank you, Ms. Sikorsky. Mr. Breskel, do you have any questions for Ms. Pease?
No, Your Honor, but I may have failed to ask the residency requirement at the beginning of my questions for my client.
Please.
We got it.
I'll ask it just in case. Andrew, have you resided in the state of Michigan for 180 days before filing this complaint?
That's there.
And at least 10 of those were in Monroe County?
I think the Canada, what? I'm sorry.
At least 10 days in Monroe County?
Yeah.
Okay, thank you, Judge.
Thank you, Mr. Breskel. Based upon the testimony that's been presented this morning, as well as the complaint filed in this case, the court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed. It remains to be seen whether or not there's a chance of reconciliation. The court will, at this time, reserve all outstanding issues. The scheduled matter for a pretrial conference will vacate the July 8th pretrial conference. Is that what's being requested?
Yes, Your Honor.
Yeah.
And have you notified Ms. LaPrade that the mediation on that date can be canceled as well?
Yes, Your Honor, she's already acknowledged it.
Thank you. So the pretrial of July 8th is at 8:30 is vacated, and we'll send out a notice of a new pretrial. Do you intend to reschedule mediation with Ms. LaPrade, or do you believe it's not necessary?
At this time, I'm hopeful that it will not be necessary. I'm sending Ms. Zagorski's office a proposal letter in today or tomorrow's mail.
All right. Thank you. So a pretrial, we have mid-July, late July?
Your Honor, it's going to be tricky for my schedule either way, so we might as well just pick a date, and if there's a conflict, I'll notify everybody.
Certainly. Do you prefer a Thursday or Friday?
I have no preference at this point, Your Honor.
Ms. Gorski, any preference? I suppose summertime, try to avoid some Fridays.
Whatever works for your schedule, Your Honor. I would just ask that it be later in July to allow us to send some proposals back and forth.
I agree.
26. 26. How about Thursday, July 25th at 10 a.m.?
That's fine.
That's fine, Your Honor.
All right. Court will notice continued pretrial conference July 25, 2024 at 10 a.m. That'll be a, do you want to do a teleconference or? I guess
Yes.
let's do a Zoom, just in case you've got an agreement, then the parties can confirm the agreement. So it'll be a Zoom pretrial, July 25, 10 a.m.
Thank you, Your Honor.
All right. Anything further this morning?
No,
No.
thank you for accommodating us.
Yeah, absolutely. You're welcome. Thank you for
Thank you, Judge.
notifying the court so we can at least stop the clock. So court appreciates that. All right. Now we'll conclude this matter. Everyone can zoom out. Have a good rest of the day.
Thank you.
This matter is before the court for a continued pretrial conference. The same is being conducted via Zoom. Present is Attorney Anthony Brusco, representing the plaintiff, Andrew Pease. Mr. Pease appears to be present with Mr. Brusco. In addition, Attorney Maria Zagorski is present representing the defendant, Amber, and Ms. Amber is present with Ms. Zagorski. Good morning.
Good morning.
Good morning, Judge.
And Mr. Brusco, Ms. Zagorski, what's the current status of this matter?
Your Honor, I believe the parties are going to attempt reconciliation. It's my understanding that we're going to enter a stipulation to dismiss without prejudice to give them a period of time to try to reconcile. And if they cannot, they're going to let their attorneys know, and we're going to put together a global resolution to submit to the court as a final judgment entry along with a stipulation to enter that judgment, if that is agreeable to the court.
Wonderful. That's good news. Ms. Zagorski, is that correct? Is that also the intent of Ms. Pease?
It is, Your Honor.
Well, Mr. and Mrs. Pease, it's worthwhile making another effort to preserve your marriage relationship of 10 years. You obviously brought 3 children into this world. So the court certainly applauds your willingness to at least to continue efforts to maintain the marital relationship. Who will prepare the stipulated order? Mr. Brusco, will you prepare that, submit that to Ms. Zagorski?
I will, Your Honor.
Okay, and of course, you know, the court's position is, at least it stops the clock. Actually, took the proofs back in June. If the court would allow the case to be reopened upon filing of a motion, I would just ask that the parties perhaps schedule mediation with Mr. Walker prior to scheduling that motion to reopen this case for hearing.
Of course, Your Honor.
All right, do either of you want to voir dire your respective clients on the record this morning?
No, Judge.
No, thank you, Your Honor.
All right, thank you, Mr. Brusco and Ms. Zagorski for supporting the efforts of your respective clients, keeping the communication open, and the court is pleased to enter that order of dismissal without prejudice upon receipt. Good luck, Mr. and Mrs. Pease.
Thank you, Judge.
You're welcome. All right, that will conclude this matter. Zoom out. Have a good rest of the day.
Thank you.
Thank you, Your Honor.
So welcome.
Thank you very
For the
much.
record, the DO is a post-judgment case regarding sale of the marital home, enforcement of the terms of the judgment of divorce. The other matter is the personal protection order. That is respondent Megan Ray's motion to terminate the PPO entered in favor of Jerry Ray Jr. on May 20th, 2024. Present is Attorney William Godfrey representing Jerry Ray Jr. Mr. Ray appears to be present with Mr. Godfrey. Attorney Petrangelo withdrew representation of Megan Ray in both cases. With John Danielski, Attorney John Danielski has appeared this afternoon. Mr. Danielski, will be fine appearance in both matters?
Yes, I was just retained Monday night, Your Honor. I sent my runner. I didn't, but yes, the answer is yes.
Okay. The court's frustrated with this case coming back. The parties have not complied with orders of this court. So they should resolve the mess that they've created. The court has very little patience with both parties. So what you're asking to adjourn this matter, I've reviewed it, I prepared for it, I've spent unnecessary time trying to, and I suggest the parties, if they can't resolve it, I'm going to appoint a receiver to handle the sale of the real estate, and they can pay for that receiver.
Well, Your Honor, Mr. Godfrey and I have worked together for a long time. We did have a conversation yesterday. I apologize for not contacting the court right away regarding the adjournment. I just got involved, and as Mr. Godfrey knows, and I think Your Honor knows, Ken is leaving me.
It was Monday night. Today's Wednesday, Mr. Danielski. A little heads up would have been nice.
Yes. I apologize, Your Honor. I wasn't sure what was.
Are we moving toward a resolution, Mr. Godfrey?
Yes, I spoke to Mr. Godfrey, and I plan on. I haven't reviewed the whole file. I will have it reviewed by Sunday, Your Honor.
Two simple issues, Mr. Danielski. Two simple issues: sell the home and entry of a quadro.
Well, a receiver may be the right way to go, but I'd like to talk to Mr. Godfrey first to see if we can resolve it. Obviously, I agree, Your Honor. These are simple issues. When I was contacted by Miss Ray, I said, well, this should be simple, should be easy. So I have to look at the file and find out what the heck's going on. Why isn't it easy? Or why hasn't it been easy? But I'm hopeful to get it resolved. Hopefully we can get it done, Your Honor.
Have you reviewed Mr. Petrangelo's memorandum that he filed with this case on behalf of Miss Ray?
I have it in the file, Your Honor, but once again, I was retained. I was in trial all day Monday and I was in a mediation almost the whole day yesterday, and I haven't had a chance to review everything. So I'm gonna be here all weekend and I'm gonna read
Just
everything.
want to make sure you had it, and because Mr. Petrangelo lays everything out. And of course, the court, as previously ordered, Mr. Ray was to, of course, Ms. Ray was to remove personal property from the home on May 18th. She didn't do that. Mr. Ray was to provide information regarding the quadro and cooperate. He apparently has not done that. So neither party has done anything cooperating with this court. So if there's not a resolution, the next week, court's can order a plain receiver.
Seems like a simple case to me, Your Honor. I just have to read everything to find out why hasn't this been done.
Mr. Godfrey, your thoughts?
Judge, the problem that I had once I got involved in the case is as to the judgment of the divorce, as to the quadro on top of page 5 of the judgment, it merely says to the value of the retirement account shall be equalized. My client was of the belief it's the marital portion. I don't have a transcript, or I was hoping to work out with Mr. Petrangelo that it would be the marital portion of the retirements that would be divided. Mr. Ray does have some premarital portion. Mr. Petrangelo and I had talked about that at length, but he no longer is in the case. I've talked to Mr. Donalinsky about it, and we're going to talk about that and see if we can get the global settlement. The second issue that is complicating it, not so simple, is on page 2 of the judgment. It refers that plaintiff, that's the wife, will start contributing to the mortgage payments, which she hasn't done, but then which I can calculate pretty easy. That's $500 per month. There's 10 months, it's $5,000. Not difficult. But the next sentence reads, and I didn't draft this judgment, nor did John, all other household bills will be paid by the party that has previously paid them until the house is sold. My client is of the belief that his ex should have been paying 3 bills. Mr. Petrangelo and I discussed that. There was some disagreement, and I'm not sure where that ended because Mr. Petrangelo isn't part of that anymore. So those, while they're not terribly complicated and they're not terribly huge in monetary amount, I think with a new attorney, and John and I can sit down and he's going to work on Sunday, and he said he would have an email to me Sunday night, first thing Monday morning, and that's why we're asking the court to entertain us next Wednesday.
Are you available at 3 o'clock?
Judge, we were looking at hopefully the first thing in the morning, only because I've got a mediation scheduled in the afternoon of that date.
30. Got some every 30 minutes, Mr. Godfrey.
8:30, Judge, 8:30 or 9 in the morning.
Got some at 8:30. I've got something every 30 minutes on July 3rd. Okay. The only time I have available is 3 o'clock.
I will make it work, Judge.
I'll make it work, Your Honor.
Right. How many years does Mr. Ray, for the court's information, claim his pension was premarital?
Judge, I've got the dollar amount exactly as $4,936.05, and that's as of the month of marriage. And then the month before he got, or they got divorced, it was $35,160.34. So it's just whether or not we subtract $4,936.05 or not. That's the question.
Right, and Miss Ray had a very small, nominal, I think, what, $14, $15 premarital on her.
And I've got that paperwork. It's $15, Judge, and I'm not going to spend time subtracting $15 out of this equation.
Right, and with respect to the $500 payments, obviously, Miss Ray Compke, I think she vacated the home. And I think the intent of the parties was that the status quo, so whoever paid those miscellaneous household bills prior to entering the judgment would continue paying those until the home was sold.
And that was our belief, Judge.
Judgment.
Right, that was our belief, but there was balking about paying for it. My understanding was she was responsible for the electric, water, and garbage, and she did not pay those.
Okay, if that was the status quo, if she was paying those prior to the judgment, then she should continue paying those. The judgment does have the language status quo in parentheses.
It just didn't, it didn't describe what that status quo was. That's, so.
I think the court would probably need to take testimony in terms of the prior history, who had been paying them during the pendency of the divorce action.
And that's what I assumed the court would do, and that's what I had indicated to Mr. Petrangelo.
Right. Likewise, with respect to the retirement, I'll let the parties work through that, but if in fact there's common interpretation would be that they would divide the marital portion of the retirement of the pensions. But I'll leave that to counsel if they want to argue that. We're talking pretty short-term marriage of 3 years. So the basic people should be back in the position they were. So if in fact there's disputes about the retirement, that would be the court's inclination is to certainly hold off making a decision until I hear testimony for the argument. But it seems like the marital portion of the retirement should be the ones that are divided. But in any event, court will adjourn this matter to July 3rd at 3 p.m. And we'll also adjourn the PPO, the motion to terminate the PPO on the same day and time.
Thank you, Judge. If we have an agreement, would the court entertain us earlier?
Absolutely. You call and we'll squeeze it in. If we don't need to, if there's no further argument or testimony to be taken, just call me and we will squeeze it in. Even earlier that July 3rd, if we have some resolution that morning, we can do it like at maybe 8:45, 9:15, something like that.
I always appreciate the court taking agreements, Judge. Thank you.
Okay. All right, Ms. Bruff, you wouldn't mind to indicate prepare an order that both these matters are over by agreement to July 3rd, 2024, 3 p.m.
Your Honor.
And I would hope that Ms. Ray will get her personal property out of the house in the meantime. You get some of these little things. Let's get these things done. She was previously ordered to do it on a certain date. She didn't do that.
Your Honor, if I didn't want to take time on the record, if Mr. Godfrey could be available for a phone call right after the hearing, I want to set up a time for him and I to talk on Monday that works for both of us, and we can talk about this, what Your Honor just mentioned, this personal property.
That'll be fine, Judge.
Okay.
We've already spoken today a couple of times, Judge, so hopefully I'll call John and we'll do it right now.
Well, you got the parties present. Right. Thank you. All right. This matter is adjourned. See you next
Thank you,
week.
Judge.
Thank you. Judgment. This hearing is being conducted via Zoom. The President's Attorney Christina Hills representing the plaintiff, Angela Zagar. And you are Angela Zagar, correct?
Yes, I am.
All right. And next to you is Brooke Zagar.
Correct.
Right. Good afternoon. Ms. Hills, the court would note that the 6 months statutory timeframe expires August 27th. So perhaps you can address that in your examination of the plaintiff. That she is asking the court to waive the balance of the waiting period under the judgment of divorce today.
Yes, Your Honor.
Right. Ms. Angela and Ms. Brooke, can you both please raise your right
You are
hand
the
before-
plaintiff in this case, correct?
Correct.
The time you filed your complaint for divorce, had you been a resident of Michigan for at least 180 days?
Yes.
And of Monroe County for at least 10 days?
Yes.
Is it true that there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed and there's no reasonable likelihood that your marriage can be preserved?
Yes.
Are either of you pregnant?
No.
Right. You have one minor child, Miles, who is age 7. Is that correct?
Correct.
There were no other children born to or adopted by you and Brooke?
No.
All right. And you are not asking for restoration of maiden name, is that correct?
Correct.
All right. And you're familiar with the proposed judgment which has been presented to the court?
Yes.
And you read that?
Yes.
And you signed it after you read it?
Correct.
Did you understand all of its terms?
I did.
Have you had all of your questions about that judgment answered?
Yes, I have.
Did you have enough time to think through all of these issues?
Yes.
Right. And you understand spousal support, or we also call it alimony, is barred as to both of you by the judgment of divorce.
Correct.
And you understand that means that once the judge signs that judgment, that neither one of you would be able to come back into court and ask for it, no matter what the change of circumstances.
Yes.
Right? Are you satisfied with my services on your behalf?
Absolutely.
Thank you. Are you asking the court to grant you a divorce?
Yes.
And you understand we're probably a couple of months shy of the end of the usual 6-month waiting period?
Yes.
All right. And you and Brooke are you're pretty amicable with each other at this point?
Yes.
Okay. However, do you believe that it would be in Miles's best interest to end this litigation now and to be able to move on with your lives, both emotionally and financially?
Yes.
Right. Thank you. I have no further questions.
Thank you, Ms. Hills. Ms. Brooke, will you please state your name and the current mailing address for the record, please?
Yeah, Brooke Marie
Ms. Hills, even though
Zagar.
she's helping facilitate resolution of this matter, she technically represents Angela, your spouse, and her loyalties lie with Angela. Do you understand that?
Correct.
But you've signed your name to this proposed judgment approving the terms and conditions contained therein. Is that correct?
That's correct.
Did you do so freely and voluntarily?
Yes, sir.
Okay, and you heard the testimony of Angela this afternoon, correct?
Yes, I did.
Is her testimony true and accurate to the best of your knowledge?
Yes.
You would agree that neither of you are currently pregnant, and there's only one minor child of your relationship. Is that correct?
That's correct.
Are you also asking the court to enter the judgment of divorce today rather than waiting till the end of August?
Yes.
Do you have any questions for the court?
No.
Do you have any questions for Ms. Hills?
No.
Ms. Hills, do you have any questions of Ms. Brooke?
No, Your Honor, thank you.
Very well. The court would like to thank and acknowledge Ms. Hills for her assistance in helping to facilitate amicable resolution. The court would applaud the two of you for reaching your own agreement, which is wonderful regarding custody and parenting time and so forth. Based upon the request of both parties, the court will in fact waive the balance of the waiting period. The judgment of divorce today. Further, based upon the testimony that's been presented this afternoon, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is thereby dissolved, and judgment shall enter granting a divorce with bonds of matrimony. Good luck to both of you. That will conclude this hearing. You can both zoom out. Have a good rest of the day and good luck.
Thank you so much.
Thank you.
Welcome. Thank you, Ms. Hills. For the record, this matter is before the court on the plaintiff's the plaintiff's objection to a child support recommendation, as well as defendant's objection to a child support recommendation, as well as plaintiff's motion for a vocational assessment of the defendant. This hearing is being conducted via Zoom. Present is Attorney Kimberly Kuhn, representing the plaintiff, Ashley Hobson Calhoun. Ms. Calhoun is present.
Hello.
In addition, Attorney Maria Zgorski is present representing defendant Matthew Hobson, and Mr. Hobson is also present. Good afternoon, everyone.
Good afternoon, Judge.
Okay, Mr. President, provide the court fine recommendation commencing December 1st, 2023, that the defendant paid child support in the amount of $180 per month. It's based upon the plaintiff having 56 overnights, defendant having 44 overnights. I'm sorry. It's based upon the plaintiff having 212 overnights, defendant having 153 overnights. Uninsured medical expenses shall be shared as follows: plaintiff paying 56%, defendant paying 44%. And there's also the issue of the vocational assessment. Current support is the recommendation was 227, so this today is somewhat less than that. Ms. Kuhn, I was going to hear from you first.
Sure, Your Honor. So I was able to subpoena work records of Mr. Hobson. And when I'm looking at all the days that he doesn't work, like there was none in April, there were 3 in May. I guess he takes jobs and gets commission, and when he's done with the job early, he's done with the job early. We feel that he is absolutely able to work, as stated on his responses to my first set of discovery. He said he has no limitations with regard to his health that would not permit him to work full-time. There's concern with what we've received that he doesn't work full-time and that he certainly could work full-time. And he also lives at his parents' home under housing and expenses. When I asked how much he pays for rent or mortgage, he doesn't pay anything. All he pays is his phone bill and car insurance, and that's it. So I believe that given that he is getting in-kind payments, or he's receiving in-kind income under the child support formula under 2.01D, that should be also included in his income, since he doesn't work all the time, and he obviously doesn't have to. So, Your Honor, I'm asking that there be income imputed to Mr. Hobson for not having to pay utilities, not having to pay rent, not paying a mortgage, paying very few bills, or that he submit to a vocational assessment so that we can get a better picture of what Mr. Hobson is able to do. It's my understanding that he was in the carpenters union, so he does possess the ability to work in the trades. So I'm making those arguments, Your Honor. My client's not happy with the child support number. She feels that he's absolutely capable of earning more and should be paying more, but is choosing not to for this very reason.
Would you like my response, Judge?
Yes, please.
Thank you. Ms. Kuhn may make those arguments, but that doesn't create money where none exists. And the fact is that my client does work full-time. He's not salary and he's not paid by the hour, he's paid by the job. And we have provided his pay records that show that he's paid for piecework and there's a special rate for drive time. And he explained very clearly that he gets his job packet at the beginning of the week, and for as long as it takes is what he works. Ms. Kuhn was informed that the records that she is looking at have to be put together to reflect both timesheets and what he writes in. For example, he explained that when he is washing the windows of a high-rise building, every time he repels, he gets paid. So determining what he makes isn't as simple as looking at his pay stub, but the bottom line is that he works full-time. It can be seasonal at times, but it is a full-time job. His W-2s from last year were provided. Ms. LaPrade ran the child support based on his income from last year. We've given all of his pay stubs from this year. It shows that he is working, and in fact, the mothers of his children get more of his paycheck than he does. The reason that he lives with his parents is, for example, the most recent paycheck that I'm looking at, after taxes and child support were deducted, as they should be, he was left with $200. That was his income. And he's working full-time. The in-kind income argument just simply doesn't fly. He can live with his parents if he chooses. That doesn't mean that we impute money to him. He lives with his parents because he's trying to pay his child support. And as I stated in the response to the motion for the vocational assessment, he had to cash out his annuity to catch up his child support because he was facing felony charges because he never reduced his child support after he left the union. He left the union because they weren't giving him enough hours. I mean, my client's frustrated because he's criticized if he does and he's criticized if he doesn't. If Ms. Kuhn wants to spend her client's money on a vocational assessment to confirm that he threw out his back and injured his body while he was working for the union with his high school education and no special training, I guess she can do that and I will make him available. But every time we do this, he misses a day of work. He can't take out of jobs because he has court. So he's a hamster on a wheel here. And I think that arguably, Ms. LaPrade's recommendation is high because I don't agree with the number of overnights, but whatever, this has to stop. He has to be able to work and pay his support. So we're asking the court to adopt the recommendation by Ms. LaPrade. She went through all of this and that is her recommendation and we will live with it.
Your Honor?
Mr. Referee McKee did in fact impute 40 hours a week to Mr. Hobson, did he not?
He did.
Even though he's seasonal?
He did. That was one of the bases of my objection. Ms. LaPrade used his actual income from last year.
Okay. Well, all right, Ms. Kuhn.
So in Mr. Hobson's answers to my first set of discovery, when I asked him if he had any medical conditions that would negatively impair his ability to work, he said no. He's not under any care of any physician for medical treatment, and he stated that he is able to work and he does work. So there's absolutely no reason why Mr. Hobson can't work in the carpenter field, or
with enough
work more.
working hours.
Hold on.
Or why he shouldn't be imputed income for the in-kind payments the in-kind income that he has. He doesn't pay any rent. He He doesn't pay a mortgage. He doesn't pay utilities. He pays nothing.
Right, if he chooses to live with his parents the rest of his life, he could do that, but the court would hope that he'd want to get out of that situation at some point in time. If he does, the court would agree he can make more money as a carpenter, but he chooses not to. But the court has a hard time with seasonal work. People are seasonal jobs, landscaping, they need to find a job in the wintertime if he's not doing snow removal. But so at this time, the court will deny the objections of both parties to the referee recommended order. The court believes that Mr. McKee properly imputed full-time income to Mr. Hobson. It's not as much of the carpenter. So the support will be ordered in the amount as recommended by Mr. McKee, $227 per month, retro to December 1st, 2023. With respect to vocational assessment, I guess we can review this again. Ms. Kuhn, I said, I don't know if it's worth the expense. Obviously, if you're Ms. Zagorski, this case, she has no objection, but be at your client's sole expense.
I would want to talk to my client, Your Honor. Can I take a minute to talk to her in the breakout room?
Certainly.
Yeah.
Ms. LaPrade, should we do a de novo order since this is an objection to
Yes, sir. I'm fixing it right now. I saw objection to the child support and I should have changed it when they said referee McKee. I apologize.
Your Honor, we're gonna dismiss the motion for a vocational assessment. It's
we'll just note you're gonna withdraw it at this time.
okay.
Very well. With that, again, the court will deny the objections of both parties to the friendly court recommendation. The court will in fact adopt Mr. McKee's recommendation of $227 a month, effective December 1st, 2023. Now we'll conclude this hearing. Everyone can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
You too.
Thank you, Ms. Brad.
Thank you, Your Honor. Give me just a moment and I'll get that in your de novo queue and then I'll delete the.
For the record, this matter is before the court and the defendant's motion to modify custody and parenting time. For the record, this hearing is being conducted via Zoom. This court did enter an ex parte order on June 3rd, 2024, requiring mother's parenting time to be supervised. Set the matter for today's date and time. Present this afternoon is Attorney Kimberly Kuhn, present for the defendant father moving party. Ms. Kuhn, you've been contacted by Attorney Eric Langton, who advised that he will be filing an appearance on behalf of Ms. Burke. Is that correct?
That's correct, Your Honor.
Mr. Langton has not contacted the court. He's not filed an appearance. He's not here today. But presumably, does Mr. Langton understand that this ex parte will continue?
I hope he does.
Okay. We should probably get an order. I don't know if someone will be able to front the court, get an order entered that the ex parte continues until further order of the court.
That would be fine.
Services involved.
Yes, I could do that, Your Honor, if you want me to meet with the front of the court. I mean, that's my expectation.
Ms. Stephanie has appeared.
Perk is here too.
You just want something saying that.
I'm sorry, just so far, Ms. Burke did appear.
It's just coming in now.
We can ask Ms. Burke if she agrees to for a continuance. And you have no objection to a continuance, Ms. Kuhn?
No, I told Ms. Coulter that I did not have an objection to a continuance.
And Ms. Burke is appearing on. Ms. Burke, can you hear the court?
Yes, sir. I'm sorry. The audio was off. Yes, sir.
All right. Good afternoon. We just called this case of Jenna Burke versus Mark Mullins. The court, the president is Attorney Kimberly Kuhn. The court has been informed that you have retained Attorney Eric Langton. Is that correct?
Yes, sir.
Okay. Mr. Langton has not filed an appearance. He's not appeared appearance in another court. But do you understand the court's ex parte order will continue, that your parenting time must be supervised until further order of the court?
Yes, sir.
Who is currently supervising your parenting time?
Dad.
Your dad, or you talk about Mr. Mullins?
Mr. Mullins. Yes, sir.
Okay. All right. Ms. Kuhn, do you have any update from Protective Services, the status of their investigation?
I do not, Your Honor.
Right. Ms. Burke, have you been interviewed by Protective Services?
Yes, sir. Yeah, the initial interview. Yes.
Other interview scheduled?
No, I've already had the interview.
All right. All right, the court will simply order that the mother's parenting time continue to be supervised. The ex parte order of June 3rd will continue until further order of the court. Ms. Kuhn, did you and Mr. Langton talk about time frame for adjournment?
I did, Your Honor. The communication was going through my paralegal and Jill Coulter, who is Mr. Langton's paralegal. So if the court would be inclined, I can get an email chain from my paralegal to the court to get dates.
We are available at July 10th. Are you available on July 10th?
I would be
July 10th at 1:30? Otherwise,
at 1:30. I have a Zoom hearing in Toledo, Your Honor. I do have July 10th isn't going to work, Your Honor. I have an in-person in Ohio at 9, and then I'll be back by noon. And then I have a Zoom at 1:30, a final pre-trial.
23rd, 24th. How about August 7th?
What time, Your Honor? Yes.
8:30?
That's fine.
Burke, the court's going to adjourn this matter to August 7th at 9:30. Make a note and contact Mr. Langton's office. Let him know. I'm sorry, 8:30. August 7th, that's a Tuesday at 8:30.
Okay.
Yep, I sure will, Judge. Thank you.
And in the meantime, your parenting time will continue to be supervised.
Yes, sir.
Ms. Spratt, if you could prepare notice, that'd be wonderful.
Yes, sir.
There's adjourned to August 7th at 8:30. Noting that Ms. Burke did appear, and Attorney Kuhn for Mr. Mullins. All right, thank you, Ms. Kuhn, for appearing. Do you have any questions, Ms. Burke?
No, Your Honor.
Okay, all right, we'll see you on August 7th at 8:30.
Okay, thank you very much.
Thank you, Judge.
Thank you. For the record, this matter is before the court for the purpose of reviewing plaintiff mother's parenting time. This hearing is being conducted via Zoom. Present is Attorney Eric Langton representing the plaintiff mother, Jenna Burke. Good morning, Mr. Langton.
Morning, Your Honor.
Ms. Burke appears to be present. In addition, Attorney Kimberly Kuhn is present representing the defendant father, Mark Mullins, and Mr. Mullins is present with Ms. Kuhn. Good morning, Ms. Kuhn.
Morning, Your Honor.
For the record, the court entered an ex parte order on June 3rd, 2024, which required that a mother's parenting time be supervised. The matter was scheduled for hearing on June 26th. Ms. Burke returned or appeared at that time. In case you wish to consult an attorney, the matter was accordingly adjourned to today's date. The ex parte order continued. Parties this morning have confirmed at the front of the court. Ms. Brower, good morning, Ms. Brower.
Morning, Your Honor.
Ms. Brower has provided the court with following recommendation that the ex parte order of June 3rd, 2024 shall continue. The mother shall continue in treatment and submit to random drug screens through Catholic Charities. In addition, the mother shall sign a release form for her records through Catholic Charities. The parties will appear back before this court on September 24th, which is a Tuesday at 9 a.m. to review mother's parenting time. And the interim mother's parenting time would just simply be supervised, but the same schedule would continue. That's a recommendation. Ms. Kuhn, is this recommendation agree with your client this morning?
It is, Your Honor.
Thank you. Mr. Langton, is this recommendation agree with your client?
Yes, Your Honor.
Okay. Who is currently supervising the parenting time? Maternal grandmother?
My client is currently supervising, and there's also an aunt, and the parties have been able to work really, really well together to figure out supervisors. So they work very well. It's a case where parties care about each other. And I know my client really wants Jenna to succeed. Jenna has been very respectful. She admits that she does have a problem. So it's a case where everybody, understands what's going on, and the parties have worked really, really well together to ensure that visits are occurring and they're able to agree on supervisors.
Wonderful. Obviously, it's important that mother continue to have that relationship with the 5-year-old child. Ms. Kuhn or Mr. Langton, do either of you want to voir dire your respective clients regarding this recommendation this morning?
I don't need to, Your Honor.
No, well, I don't need to either, Judge. Thank you.
Very well. All right, I'd like to thank Ms. Brower for her assistance. And Ms. Burke, we just want you to get better. So focus on your own wellness. You've got to be well in order to be a great mother to your child.
Yes, sir.
So I'm pleased that you are open-minded and willing to work with Mr. Mullins to be well, so you can parent your child. So hopefully we'll have progress between now and September 24th. The court will adopt the recommendation, copy mailed out to council. We'll see everyone back on September 24th at 9 a.m. And that will conclude this hearing. And we can zoom out. Yes. I'm sorry, anything further?
No, Your Honor, thank you so much.
All right, you're welcome. Thank you all. Everyone can zoom out. Have a good rest of the day.
Thank you.
Thank you, Judge.
Thanks, Eric.
Attorney Kimberly Kuhn is present, representing defendant Father Mark Mullins, and Mr. Mullins is also present. Good morning, everyone.
Good morning.
Morning, Your Honor.
The parties have conferred with Ms. Patrick. Good morning, Ms. Patrick.
Morning, Your Honor.
The following recommendation. Plaintiff mother shall have phone calls with minor child every day at 5:30 p.m. Plaintiff mother will initiate the calls. Mother's parenting time will continue to be supervised with the defendant. Father is a supervisor every Tuesday, Thursday, and Sunday as times to be agreed upon by the parties. If days need to be changed, plaintiff mother will provide defendant father 24 hours notice. The parties will appear back for his court to review mom's parenting time on November 6, 2024 at 8:30 a.m. Further, the plaintiff mother will sign a release for sessions and drug tests to be sent to Ms. Kuhn. Plaintiff mother will sign a release for Catholic Charity so Ms. Kuhn can contact that agency. Also, plaintiff mother will sign a release with the doctor she is currently seeing for substance abuse issues so Ms. Kuhn has access to those records. That is a recommendation. Mr. Langton, is this recommendation agreeable with your client this morning?
It is, Your Honor.
Thank you. Ms. Kuhn, is this recommendation agreeable with your client this morning?
Yes, Your Honor.
Counsel, do you wish to voir dire your respective clients regarding this recommendation?
No need to.
No, Your Honor.
The court would note that the parties did participate in discussions with Ms. Patrick. Thank you, Ms. Patrick, for your assistance. Since both parties are agreeable, the court will adopt the recommendation. We'll put this matter back on our docket to review mom's progress in November 6 at 8:30 a.m. All right, that concludes here. Now we're going to zoom out. Have a good rest of the day.
You too.
Thank you, Your Honor.
Thank you, Judge.
Thanks, guys.
Thank you. Mullins, of course, is present. Good morning, everyone.
Good morning.
Morning, Your Honor.
The parties have conferred this morning with the front of the court. The court has received the final recommendation that mother's supervised parenting time shall continue as previously ordered with family counseling shelter services, I believe. That's court's recollection. The father shall continue to be the supervisor of that parenting time. That is a recommendation. Mr. Langton, your client's position on this recommendation this morning?
We are agreeable, Your Honor.
Ms. Burke, is she still engaged in treatment?
Yes, Your Honor.
Yes, Judge, yes.
Good. Ms. Kuhn, is this recommendation agreeable with your client?
Your Honor, the previous order that we're affirming as our permanent order for the time is that the phone calls will continue between mother and the child at 5:30 every day. And mother's going to continue to initiate the calls. And father supervising mother's parenting time. It's every Tuesday, Thursday, and Saturday. Times will be as the parties agree. And if days need to be changed, mother will provide father with 24 hours notice. And they have been working together really, really well. And we believe that they will continue to be able to work together very, very well. So my client is in agreement with that recommendation.
All right, thank you. The recommendation does not contain a review date. Obviously, either party can always petition the court, but is the court understanding correct that the parties are working well together? And obviously, if Mr. Mullins receives reports from Catholic Charities and he feels that mother is doing well, obviously they can always agree to facilitate some unsupervised parenting time. Is that correct?
That's correct.
That is correct, Judge. And I just wanted to clarify, the order that I had says Tuesday, Thursday, and Sunday. I know Ms. Kuhn said Saturday.
Oh, I'm sorry.
That was just a misstatement.
You are correct. I apologize.
Okay.
That's fine. But yes, Judge, that is the intention. The parties are working well together. So we're not requesting another review date.
Wonderful. Wonderful. That's court's pleased to hear that. So the court will adopt the recommendation. Hopefully the parents can work together for the best interest of their daughter, and that mom will get Miss Burke, you need to take care of yourself first before you take care of your daughter. So,
yes, Your
please
Honor.
be strong, continue that treatment.
I am,
that's
sir.
the best thing you can do for your daughter.
Yes.
And the court's pleased Mr. Mullins is working with you because he wants your daughter to have a relationship with her mother. So,
Yeah.
So work together. All right. The court will adopt the recommendation. Thank you, Ms. Brower, this morning, as well as Mr. Langton and Ms. Kuhn for helping facilitate this resolution. No future review date. Obviously, anyone can petition the court if they want some other relief.
Okay. Thank you very much, Your Honor.
Thank you,
You're
Judge.
welcome. Now, close here and have to zoom out. Have a good rest of the morning.
Thank you, Judge. You too.
Have a good day.
Thanks, guys.
Thank you. Bye.
Bye.
It's always nice when we don't have to keep it in our docket.
Absolutely.
Some of these, we just have to give review dates just to get let's try this, but it's always nice to.
No, the parties do work really well together and they have since the beginning. So we're hopeful that they can increase parenting time for mom and they won't have any issues moving forward.
It was interesting. I had a case yesterday, and I'm not sure if it's Dr. Drescher. Let's call Skatinsky. Let's call him. So you might call him, Sarah. Just call him. Just ask him. Call Attorney Skatinsky. No. I'm sorry. If you could just phone him and just tell him that their side is not a peer, so we're going to deny the motion to modify, and maybe that's what he wants. Here, his phone number's right there, and his appearance. Henry, can you enter the file, please? There you go. Yeah, he's not required to appear because we're going to deny the motion, so that maybe he's fine with that. Okay.
You guys have continued,
Okay, Sarah just called Walt Skatinsky. Skatinsky, he didn't appear on the 2:30 PPO.
Oh.
And usually, an attorney, we just call him to say, hey.
Oh. So if you see people coming in, I just want.
Okay, thank you.
I'll try to update her.
Coons is present. Is Ashley Coons present on audio?
Yes, I am, sir.
Right. Good afternoon, Ms. Coons. Mr. Walker, good afternoon.
Good afternoon, Your Honor.
What was the primary issue? Was it parenting time that was discussed in mediation?
Yes, Your Honor, it's parenting time and child support.
Okay. Was there any agreement or resolution, or did parties need additional discovery?
There is an agreement, Your Honor, regarding child support and at least temporary agreement with parenting time with a continued mediation date.
Okay. Mr. Savage, do you want to put the agreement on the record, or do you want Mr. Walker to do so?
Mr. Walker graciously offered to undertake this task.
All right, Mr. Walker.
Yes, Your Honor. The parties have agreed that parenting time is going to be as follows. Defendant's parenting time will be every other weekend commencing July 6th of this year, 2024. It will be every other Saturday starting at 2 p.m. until 6 p.m. and every Sunday starting at 9 a.m. until 12:30 in the afternoon. Defendant Scott Corns has agreed that if he is unable to make his parenting time, he will notify Ashley on the Friday before his parenting time. He will also notify Ashley if he is going to be 15 minutes or more late to his parenting time. That is the extent of the parenting time agreement. Child support, we also discussed child support, and there's an agreement that Scott will pay, or defendant will pay to plaintiff an amount of $496 per month for child support. That breaks down to $472 a month base support and $24 a month ordinary medical. That gives Scott a 75 75 average overnights per year. And any uninsured medical expenses would be paid 63%. Sure, that's right. 63% for defendant, 37% for plaintiff. We did not, however, Your Honor, I just thought of this, discuss an effective date for support. That is the one thing that I missed.
What was the last issue that was missed?
Yeah, the effective date of support.
Oh, effective. When was the motion filed for support? And the parties agree upon a commencement date, Mr. Savage?
The effective date of this order will be March 1st. Correct, Mr. Walker?
Yes, Your Honor. Actually, there is an order dated March 3rd from that Your Honor signed. It says child support shall be referred in front of the court with the effective date or start date of March 1st. So the
Okay,
order
very well.
already has an effective date of March 1st, 2024.
Very well. So, and of course, Mr. Savage, you'll prepare a uniform child support order with that child support amount as well as commencement date. Is that correct?
I didn't understand the court.
Mr. Savage, you'll prepare a uniform child support order reflecting that amount of child support as well as the commencement date?
Yes.
All right, Ms. Kuntz, did Mr. Walker accurately state your agreement regarding interim parenting time as well as child support?
Yes.
All right. And Mr. Savage, Mr. Walker accurately stated your client's agreement as well?
Yes.
Okay, do you wish to voir dire either party, Mr. Savage, regarding
No.
this agreement?
No, I do not. He's been very active in the discussion thus far.
Very well. Ms. Kuntz, do you have any questions for the court or any questions for Mr. Walker or any questions for Mr. Savage?
No, I do not, Your Honor.
Mr. Savage, you will prepare an order incorporating this agreement. Is there another mediation scheduled, Mr. Walker, or is that not necessary at this point?
Yes, Your Honor, there is a continued mediation scheduled for September 5th at 2:00 in the afternoon with myself.
At 2:00?
Yes.
And that would be regarding presumably parenting time primarily?
Yes, Your Honor.
And that's September 5th at 2:00?
Yes.
All right. So, Mr. Savage, you should probably indicate that in the record that the parties appear will mediate with Mr. Walker on September 5 at 2 p.m. via Zoom. And then they can subsequently appear before this court for a review if necessary. To put it on the record, I'll make sure we're available, have the file up here. And if there's any issues the court needs to address, the court will be available to do so. So if you can put in the order that the parties meet with Mr. Walker September 5 at 2 p.m. via Zoom, and perhaps include the order Mr. Walker's Zoom ID number. Do you have that handy, Mr. Savage?
Your what?
Do you have Mr. Walker's Zoom number?
Yeah, yes, I have the Zoom number.
Okay. Perhaps we can put that in the actually in the order. Then the parties can subsequently appear before the court for review after they conclude with Mr. Walker on that date.
You want the Zoom numbers in that order?
All right, Ms. Kuntz, do you have is there any other concerns, questions on your part?
No, there's not, Your Honor.
All right, the court will adopt the agreement of the parties relative to child support and parenting time, and we'll see everyone back on September 5 after your 2 p.m. mediation with Mr. Walker. And Mr. Corns, obviously communication with Ms. Kuntz is the key. So please be considerate. I know it's a long distance, so if in fact there's a delay or you're unavailable, please notify her as soon as possible. All right, if there's nothing further, Mr. Savage, I will conclude this matter. Thank you, Mr. Walker, for your assistance. Thank you, Mr. Savage. Have a good Zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
Thank you.
You're welcome. For the record, this matter is before the court on the petitioner, Kerry Smith's motion to modify a personal protection order. The matter was scheduled for 2:30 this afternoon. It's now 3:15. Ms. Smith has not appeared, nor has responded. Michael Ciceriello. In addition, the file does contain an appearance filed by Walter Skatinski. He was unaware of the hearing. Actually, looking back at the file, his appearance was filed in November of 2023 and appeared at the last hearing in which Ms. Smith petitioned to modify the PPO. The court did modify PPO at that time. So obviously, the court now understands why Attorney Skatinski did not appear. It was not a recent appearance, but in any event, the petitioner nor the respondent has appeared. So the motion to modify is denied.